how is estate planning different if you have young children, children under the age of 18, than if you don't? Well, this part might be obvious, but the biggest difference is if you have minor children, if you have children who are under the age of 18, you gotta have in writing who you would nominate to be their legal guardian if the worst thing happened and both of the parents passed away. So that's the biggest difference, right? Now there's some other specific differences I'll talk about here in a second, but if both parents pass away, depending on the state that you live in, the laws might vary, but generally speaking, even if you and your spouse both know you want the one set of parents, one set of grandparents to become the legal guardian, that's not how it works. There will have to be, regardless, even if you have it in writing, there will be a legal guardianship proceeding in which the court is now going to name who their legal guardian is for the rest of their lives, or at least until they're 18, who's going to be their legal caretaker. And if you don't put in writing what your wishes are, who you nominate to be, then I've seen it happen all the time. There becomes a fight in court over who's going to be the legal guardian. And this typically is between the two set of in-laws. The two set of in-laws fight. Maybe you have a sibling who fights, and it just becomes a really nasty situation. And so I can't stress enough that if you have minor children, because I get clients who come to us and they're typically their 30s, early to mid 30s, and they say, look, I don't have a whole lot of money. Maybe we have a house, maybe we don't, but we have minor children. Well, you need to have some sort of planning in place. And so again, the biggest difference right there is who would become the legal caretaker. Who do you want to appoint as the legal guardian? The next piece is typically has to do with money, because again, if you don't have any money, I get that, but you probably have something. And if you have a house, there you go. You can't name a minor child as the beneficiary on a house. A 6-year-old cannot own a piece of real estate. So you need to put into place who's going to receive those things on the child's behalf. Because you might not, the child, if you name, let's say, your parents and they live in California, but you live in Florida, well, they may not want to move to Florida for the kids. They may bring the children to California. So owning that house that you have in Miami may not make a lot of sense. So you'll need to put some instructions on there on selling the property and then setting up trust for the kid, right? So big picture, you need to say how the children are going to get whatever you're leaving it to them. And if you do have some money, you may want to set some parameters in place. You may not want the kids to get $100,000, $200,000, $500,000 when they turn 18. You may want to set some money aside for them to be put towards education. Maybe they get some when they graduate, and you stagger it out between ages 21, 25, 30, 35, however you decide. So those are some conversations you would have. Really depends also on the financial resources of the people you've named as their legal guardian. If they become legal guardians and they don't have any money, well, they may need to be able to access some of the money that you're leaving for the kids so that the kids have food, clothing, shelter, all that sort of stuff. Or if they have a lot of money and they're able to take care of them, great. Now you can discuss setting up some trust for the kids. So there's not, I think the biggest thing is obviously you just got to figure out who would take care of the kids if something happened to you. Very uncomfortable conversation, very tough. I'll tell you, that's our clients have a very hard time figuring that out, because obviously you don't want anyone else to take care of your kids. You want to take care of your kids, and there's always, you're looking at flaws of why someone wouldn't do a good job or whatnot, or they wouldn't do it the way you would do it. And so it's a very difficult conversation, but having something in place is better than nothing. You kind of have to just pick somebody, the best of the worst, and but have something in writing. Again, I see all too often where parents don't have anything, and it's just it's a horrific thing. So that's probably the biggest difference. Get a plan in place that makes sure the kids are taken care of, and then you can discuss the traditional technical stuff of what they get and how they get it.